This meeting of the Administrative Reg Review Committee will come to order. Secretary, please call the roll.
Senator Senator Rocky Adams. Senator Wilson.
Here.
Senator Yates.
Present.
Representative Bridges. Here. Representative Gordon. Here. Representative Marzian. Here. Co-Chair Lewis.
Here.
And Chair West.
Here. We have a quorum present and duly constituted can do business. First matter of business is approval of the minutes of last meeting. Any additions or corrections to the minutes? Seeing none, is there a motion to approve the minutes? We have a motion, we have a second. Without objection, is so ordered. Before we call the first regulation, as usual, we'll go through some announcements. If you want to speak for or against a regulation, you need to sign up at the back on the sign-up sheet. One thing we will do, we're going to do the transportation regulation first. I think we have Representative Decker here to speak on that particular regulation. So we will call the transportation regulation first. KAR 5120.
Kentucky Transportation Cabinet 603 KAR 5120 for informational review.
This regulation establishes the procedures to designate or modify the type of control to be utilized for highways, including additions, alterations, requests for changes in access by permit applicants, or changing the type of access control on existing highway facility, and the revision of deeds of conveyance.
Thank you. Would you please state your name for the record?
John Johnson, Transportation Cabinet, Office of Legal Services.
Jason Sawala, Deputy State Highway Engineer for Transportation Cabinet.
Thank you so much. Gentlemen, the genesis of this is several legislators. We had some input from other legislators on some of the things that were happening on the ground as it pertains to this particular regulation. And before we do anything or take any action or anything of that nature, what we wanted to do is exactly what this committee is set up for, is review existing regulations. So that's why you're here today. So if you could, we would like you to go as in-depth as you possibly can about what this regulation does and then how it's actually enacted on the ground, how it operates on the ground.
Okay. If I'll go ahead and describe essentially three types of permitting processes involved with access to a highway. One is access by permit. That is in an area where in Kentucky it's quite common for a farmer or a business to apply for an access for an industrial use or commercial use or agricultural entrance. Sometimes we do this to widen entrances that are already pre-existing. The permit process starts in the district office through the permit section of the district office. They go in and fill out a form, TC form. It's listed in the regulation. They design the entrance, show how they're going to modify the entrance. They post a bond quite often and sometimes design the entrance or hire an engineering firm to do the design, cross sections. That's approved at the district level. And if not at the district level, it can be sent up to the State Highway Engineer's office and reviewed there. And that's one type of permit that could be issued. Other types involve partially controlled access, which is a different type of highway, heavier use. We can control access to keep safety at its peak. And then the controlled access is the interstates, the major highways where we do not want access to be allowed without approval through the permit process. And actually on controlled access, it has to be done as part of a project design. And if you're familiar with condemnation lawsuits and condemnation plans, it's always on the plans what type of access is going to remain after the project is complete. For example, if you're in an area where it's a rural section of land, it'll have access by permit most of the time. So when the project's completed, you will have a process 2 years after the completion of the project to go. You can go in and ask for a modification, addition, or even elimination of access if you so choose, but most people don't do that. Sometimes we landlock property. Examples of that occur all over the interstates, every interstate, US 60, which I'm not That's just one of the older routes that a lot of roads are built, access large chunks of farmland. That access is paid for at the time it's condemned, paid for to the extent that it's paid for forever. Sometimes the landowners desire to keep the land, and sometimes they will sell it for uneconomic remnant to the state. Access can never be provided to that unless the road is redesigned, controlled access is broken up, and they put in an interchange or something to create access, which does happen. Partially controlled access is sort of in between, and that involves a lot of times they meet with the local engineering staff, permits agents, and they redesign sections to create access points. Sometimes we will actually acquire right-of-way to provide access for a number of individuals along a narrow corridor, maybe an access point that would not be permissible by, let me give you an example. If we take a section of road 10 feet wide across a line of houses in a subdivision, we may not be able to permit access, and if there's 10 houses on that line, we may not be able to produce 10 access points. It would not be safe to dump all 10, to create that kind of safety hazard, potential of 10 vehicles entering or exiting the highway at one time. What we may do in that situation, if there's an agreement and if it's allowed, we will do a corridor road on the inside of the actual highway, which will front all the properties and will allow an access at an endpoint on each end. That would be an example of an accommodation that we make. We're restricted by what we can do by the Constitution because we cannot condemn property for private purposes. It has to be for public use. As you all know, pursuant to the Constitution, it has to be needed. So do you have any specific questions, Chairman, regarding any particular type of permitting process? Or I think that's essentially it. Now, I do have an occasion, having done a lot of condemnation work, sometimes we provide access that did not exist before. On a rare occasion, I've had the rare opportunity to file a lawsuit against MSU in Morehead, Kentucky, and we had a landlocked section of highway.
That's in my district, so be careful.
I have to be careful. Well, I was careful at the time. We condemned a nice flat piece of ground that did not have access. When we got done, we provided an access right in the front of the property. It's a couple-acre field, real near the stadium. When we got done, when the commissioners went out to review the process without going into the statutory requirement of sending commissioners out, they enhanced the value of the property. So if you seek to change access, another requirement that I've left out, oftentimes you have to select a certified appraiser to go out and appraise the property to establish how much the new access or the modification to the access enhances the value to the property. And that becomes part of the cost of creating the entrance access point or modification. With reference to MSU, they were just happy to get a nice commercial entrance to a flat field across from the football stadium. We shook hands at the mediation, went our separate ways. So we created access where there was no access before, and that's sometimes happens. And that's required by statute as well. Chapter 416 requires enhancement to be considered on changes to access.
So I'm going to jump in, then I'll open it up to other members. So let's go back to the controlled, which is, I think, why we're here today, why we ask you to come. The controlled access situation. So we have a bypass, for example. Most bypasses are controlled access, right?
That's correct.
So you have a bypass around a town. A private entity is, did you want to add something?
I do partially controlled access for a bypass generally.
That's
yes,
partially.
Yes, sir.
Let's use either example. So either a controlled access, let's use the bypass as an example,
Sure.
whatever that is.
Yes, sir.
Private entity has property on the bypass. Let's say this is a really open bypass where you don't have a lot of entrances on this section of the bypass. So a new entrance would be reasonable, a reasonable ask. Let's say they have a 50-acre tract for a new facility they want to put in there. Okay. So they, in applying for and making this design application, I'm just trying to regurgitate what you've told me. So they make their application, they submit their engineering plans to planning and zoning. It goes through all that process. In that process of planning and zoning, they also have to talk to the district, that highway district, and it goes up the food chain until it reaches Frankfurt Transportation, and it reaches that level where you have to give final approval to the design of the new entrance. Okay. So I understand. Tell me if I'm wrong that that's not the process, but I think that's the process. Next step, go into a little bit more detail about what you just spoke about with the Moorhead situation, where we talk about improving the value of the property. Like the state puts in the new entrance or approves the entrance, and then that improves the value of that tract. Therefore, the owner of that tract has to reimburse the state for that increase in value. Is that the case? Am I on track? Or
Yes, that's correct.
Can I elaborate?
Sure,
a little
absolutely,
bit?
yeah.
Sure. So as that original project was moving through for that bypass, okay, all of the property owners who were affected at the time, were worked with our right-of-way agents, okay, and the majority of the property that we purchase for roadway projects is not through condemnation. It's through just our regular right-of-way acquisition. But a small amount of our right-of-way actions do go through the condemnation process. But as we go through and do that, as John mentioned, each project has what type of access will be allowed once the project is completed. Okay, so as John mentioned, if we're building like an interstate facility or something like that, that's going to be fully controlled, no access allowed to that facility. On a bypass or similar facility, you might have what's called limited control or limited access, and that's laid out by KRS 177-315. But when that is done, the property owners adjacent there, as we are acquiring the property, the right-of-way to put the roadway, changes in access are a part of the compensation that the property owner receives. And so if we're putting that out there and access will be allowed depending on the frontage at a certain point or not at another certain point based on the layout of the highway and other access points. Basically, the access will be allowed for the type and at the location where the plan set says. Okay, and so that's constructed with the project, and at the time that we do that, fair market value is compensated not only for the property that's purchased, but also for any access changes, and that's done via deed conveyance. Okay, and so
now, are we talking about when the property's acquired for the road by the state at
Yes.
that phase?
yes, sir.
Okay, so we're not talking about my scenario.
Not yet.
I'm with you. I'm
So-
trying to clarify.
So fast forwarding, okay, to the point where then a property owner, either the same property owner or someone who has subsequently acquired that property, comes in and desires to have a change in access to permit a new access, or like you said, build a facility that requires different types of access or whatever. The process, as you laid out, it starts at the district office, and then there's a piece in there where appraisal is done to determine what the value ostensibly of that access change is. Okay, so the state acquired that type of access when that property was acquired for the roadway, and and like I said, that's recorded on the deed for these properties and things. And as people want to go and change that access, there's a process that we go through that John described. And the appraisal is fair market value of that property today versus what the fair market value of that property would be if the access changes were required, okay? Or I'm sorry, were approved, excuse me. And so basically the Commonwealth has a right that was purchased to limit access to the roadway. And at the time, like John said, that's done to provide mobility and safety and those types of things. If you think about the types of places that are partially controlled access, those are generally higher speed facilities where having more closely spaced access points would be more challenging for the drivers that were making through movements to navigate. Okay, and so as a part of the process, Like John said, an applicant has to do an engineering study that is like deals with traffic and those types of things. Has to provide a design for the entrance at some point in the process, and has to have the appraisal done between those two scenarios. Again, the fair market value of the property today and the value of the property if access were granted. Does that help?
Yes, perfect stopping point too. So where does the state get the authority to do that? Is that regulation, statute, constitution, or all three? Or I honestly don't know the answer to the question.
Well, the statute requires in condemnation in general that every condemnation consider enhancement to the property being condemned. So that's as a general rule is contained in the Eminent Domain Act, because in the example I gave you, we took a narrow strip, but the net worth of the property went up much more. It went up much more than the value of the taking. Otherwise,
So help me. And honestly, I'm just trying to understand the process. These things can get a little tricky. So I have, back to our easy example, I'm XYZ company. I purchased 50 acres next to a bypass. I want to invest in the state of Kentucky and make it a better place to live. And I get these economic incentives to locate here. I'm going to build a nice factory here next to the bypass. I apply to the transportation cabinet for a new entrance. Okay. I have my property, which abuts the right of way. The state, the property between the property and the highway is the Kentucky owned right of way, I'm assuming, or state property. And I'm saying, state, please give me a new entrance into my property so I can operate. Why? This is, I don't know the answer to this question. Why is eminent domain needed here? If that company is freely, this is my example. So if this company is freely saying, I just want an entrance to my property, state, I'll give you the land on my property. Just give me this entrance. Why does it become an eminent domain, I guess?
it's not actually eminent domain per se, but the valuation of the property is derived by the due process clause of the Kentucky Constitution, federal Constitution. Everybody's entitled to receive fair market value to their property, and that's if we purchase it. If
Gotcha.
we go in and
You're saying, you answer my question, so it's not eminent domain. You're telling me that the process that you use in that case comes from the eminent domain process. It's the same process.
Yeah, it's a fair valuation, but it works both ways.
Right.
It would depend on your scenario if the property's landlocked, already has access, if you're going to modify it, make it wider, or if it's landlocked entirely because of safety reasons. Has the landowner already been compensated for it? If so, the property's been, for example, if you could easily get a farm that looks beautiful on the interstate that has no access whatsoever except through an adjoining landowner. And we're not going to break controlled access to enhance the value of that property unless there's a major project. And in your scenario, it may be justified. Maybe a major automobile manufacturer may be coming into town, and we may want to go in and do route reconstruction and change the interchange to
Which is a whole different thing.
A whole different thing. But just for a small one-time personal piece of property, it depends on the case. It depends on how much is being changed, whether or not access was provided originally, whether it's been paid for originally. If we bought and condemned the property initially, that's why this is relevant. If it's on a state highway, at some point, a part of that property has been used to build the road.
So is there a difference made between if the state purchased the property originally,
Can be.
or let's say the new owner bought the property from another individual? Let's say it's 5 people down the chain of title, and they're just buying the property for the first time. Is that handled differently?
I think that if you buy property, the caveat emptor should apply. You need to do your title work. Quite often people buy land and I'll get a phone call. I'm allowed to have access. Nobody can deny me access. And then we find out at the end of the conversation that they may be the third or fourth owner in the property, but, they can't get to it. They need to get out and look at the property and make sure it's not swampland before they buy it.
Gotcha. I've
Can
taken
I-
up enough time.
I apologize. Can
Go
I just
ahead.
make one more clarification?
Yep.
Like I said, and over time, Kentucky, if you've ever done any type of deed work or anybody's ever read any deeds, deeds are, can vary widely, across Kentucky and across jurisdictions. But when the Transportation Cabinet purchases property, those, and as set out in the regulation, those types of restriction and what type of access is permitted or allowed, I shouldn't use the word permitted, is allowed for that property is within that deed that's recorded at the time that property is conveyed. Now, if it's been conveyed 4 additional times, I'm not sure, we obviously don't see those, so I don't know.
But it's still in the chain of title, though.
Yes, sir.
Any attorney
Yep.
is responsible for going back in the chain. So I've taken up enough time, and you guys have answered all my questions. Representative Decker is going to speak here in just a second about this particular regulation. Do we have any members that want to ask the cabinet questions before Representative Decker comes up? Seeing none, if y'all could step to the side for just a second, we'll.
Thank you.
You're welcome.
Thank you, Mr. Co-Chairs.
Representative Decker, if you would
hearing
state
this.
your name for the record, then the floor is yours.
My name is Jennifer Henson Decker. I'm a state representative from District 58. Thank you.
Please proceed.
Oh, I appreciate the department's explanation of this regulation, although I didn't hear the explanation of the designation of access by permit. So we heard testimony about 2 types of limited access highways, the fully controlled access and the partially controlled access. But there is a third type, and that is the access by permit. And I think the reasons for denying access diminish as you go down that list. Clearly, a highway has imminent reason not to grant and is not expected to ever grant access. The same is more true of the limited access road, but the access by permit is a different animal where almost from the start there is a recognition that permits will be requested and granted if they meet the terms of safety, etc. So in my county, there is a permit being requested for a access by permit road, a bypass, and that's what I'm here to talk about, and partially what they mentioned as one of the requirements. While allowing permits on this type of road are limited at some times, it is generally for the means of allowing quick dry pass through to avoid, for example, a city where oftentimes without such limited access roads around that, there will be pollution and accidents and congestion, etc. But as someone at the department once said to me, that there is a recognition that such roads, as the community grows, will be needed both locally and regionally. They will be more than just something that is needed to get around the county. They will be needed to get to things on the other side, or because the other side of the county has grown, they need to get downtown. So as the community grows, there is a recognition, especially in the access by permit type land, that permits will be granted. So I think we can all understand the requirements of fair market value being paid, as we heard, when there's a condemnation or where deeds are transferring. In the case in my county, there's no deed that's ever going to touch this requirement for a payment of fair market value caused by the permit. And what I mean by that is this land was purchased 20 years ago and has remained limited access throughout that time. Now, the deeds no longer show that, but you're correct, they'll be in the chain. But there is a recognition by the people who've bought it that access can be granted. And in fact, in this case, there has been assurances that the permit will be granted if all the requirements are met. And that is necessary because this permit is requested for a development that is going to help every person in our county. In fact, my mayor wanted to be here today but I told him I didn't think it was necessary. It's not a practical discussion, it's the legal discussion. But this development is paramount to our county, and we're getting ready to lose it because of the amount of time taken to get this permit. One of the reasons the permit has not been granted in the past few years is that one of my constituents and everyone involved in this deal are concerned that Section 4, subparagraph 6 of this regulation has a requirement that is not authorized by any statutory authority. And I'd like to talk just a minute about that. So, I have talked with various members of the DOT, and all of whom have been very gracious and helpful to me in understanding their position. But I have yet to hear any authority that I think is valid, and I want to describe what I've found to you. One of the monetary requirements in subsection 6 is that before an approved permit may be finalized, a landowner must compensate the Department of Transportation for any increase in the value of the property that will gain access to the access permit roadway. If it's attributable to the permitted access, and they value it before and after the access point is granted. For example, if the permitted access is for land valued at $1 million, before the access permit is granted, and the DOT appraises the value of that property after the permit at $1.25 million. This regulation would require the landowner to pay the Department of Transportation $250,000 because that access point has increased the property value. This property will not be sold to the Department of Transportation or bought from the Department of Transportation. The property being valued before and after will be sold to a third party. The Department of Transportation is not being compensated for any change in value. When this first arose, my constituent contacted the department and asked, "What is this charge for?" And he received an email stating, in essence, you are not adding value to your property by building the access point. We are adding value to your property by making an exception and allowing direct access to your property. So in the interest of fairness, KYTC collects this difference in value as it is KYTC's actions that created the additional value. Clearly, that explanation does not take into consideration that this value increase goes to the public at large. And to charge this individual for an increase in value of something that is built for the public at large seems not to be a valid reason. When I met with various members of the department, I was very interested to know that their position was that there is a federal regulation. I didn't hear that discussed today, but I was told there is a federal regulation at 23 CFR 710.403, which provides that the current fair market value must be charged for the use or disposal of all real property interest if those real property interests were obtained using federal funds. Well, there's no disposal or purchase of real assets here. And not only that, this this particular road was not built using federal funds. This regulation, if it applied at all, would apply to roads that are built using federal funds. When I pointed that out, I was told that it is the practice of the Department of Transportation to apply federal regulations to every road that's built, with the thought that at some point in the future, they may need federal funds to work on the road. While this interpretation of a federal reg as applying to a state-funded reg as a policy matter that is applied then to all roads in Kentucky seems to me to be the same as authorizing the department to apply any rule that they deem necessary, because I have heard that the Department of Transportation applies or interprets state law giving them the authority to construct and maintain roads as anything necessary to construct or maintain roads. That is a very broad interpretation. I think it's a policy decision to apply federal regulations to all roads and to apply it even on state roads that have never used federal funding. I think that is a policy decision that needs to be made by a legislature and not an executive agency. And for those reasons, I submit that this section 4.6 of this regulation should be found deficient.
Thank you so much. Does that conclude your?
It does.
Okay. If you don't mind,
Thank you.
I'm going to open it up. If you'll just stay there for a second.
Sure.
Does anybody want to ask Representative Decker a question? She may be able to provide clarification on her particular instance if you wish. Seeing none, if the cabinet would come back up.
May I make one other statement since you?
Yeah,
Okay.
sure. Go ahead.
That regulation, that section 4, if you look at it, I did want to point out that it requires the landowner to construct any road that uses that access point at their own cost, and to pay all costs associated with the permitting process. So if this interpretation that the Department of Transportation applies is actually applied, the landowner would have to pay for the cost of the road, the cost of the permitting, and then fork over part of the fair market value that he could realize by selling the property. I just don't see any authority for that, and it seems like a overreach. Thank you.
Thank you. If you guys would come back up. While you're getting settled, I'll give you you guys a chance to respond to Representative Decker's comments. My first thing though, my comments were going to be what gives you the authority to enact this regulation. And I think what you're going to tell me, I've got three pages here in front of me. I've got 174.80. The Transportation Cabinet shall adopt such administrative regulations and procedures consistent with the provisions of blah, blah, blah in regards to highways. That's a generic kind of catch-all. Secondly, under your general powers, 175, you have the ability to acquire and hold in the name of the authority real and personal property and to dispose of the same with the approval of the department. And then KRS 176.050, under that provision, you have the ability to promulgate regulations under 13A for the care and maintenance of roads after they have been constructed. And I think that's what Representative Decker was talking about, was care and maintenance of roads. So correct me if I'm wrong, that's where you draw your authorities from, those general catch-all provisions.
That's correct.
From I guess I'll have some questions at the end. I'll go ahead and let you respond to what Representative Decker's spoken about, and let me know if you have anything you disagree with or or would wish to comment on.
You mind if I go first?
Go ahead.
So, we did speak with Representative Decker during the session about, I believe it was House Bill 428. House Bill 428 that was filed. That's in reference to this same issue, and we spoke on the phone at least once that I can recall, but a couple of times, and she's discussed with different folks that are members of the Department of Highway staff, and the only thing that she said that I'm not sure about, because I haven't personally looked into it, is whether or not the property in question was sold, was acquired for access by permit. I would have to go back and look at the particular project where that was built in order to determine that. But other than that, I mean, as she was going through and discussing those things, the only response that I would have from the cabinet's perspective is that as we purchase that right of way in alignment with this regulation, which I believe has been largely unchanged for the last 25 years, if we purchased the right to limit access on the new facility that was going through, that would be what's triggering this sort of, I believe it was section 4, number 6, to take place. And so, John?
To follow up on that, it has to do with the taxpayers' money. We are stewards of the taxpayers' money. And in one statute you didn't mention, which is 177081, directs the cabinet to maintain, build, and design roads for public need and use. So we have to do something that's for public need and use. If we do something for a private individual, the taxpayer dollar has to be returned. So as Jason mentioned, at some point in history, that limited use access has been compensated for, in theory, by fair market value purchase. If that changes at some time in the future where access greatly enhances the value of the land, in theory, the payment to the taxpayer has to be returned at the current market value at the time of the change. And it all goes back in the formula, and before, after, and difference. And if we make the property worth more, then the taxpayer who's expended money to buy the land initially, in essence, should be reimbursed for any changes that would inure to the benefit of a private landowner without returning the money back to the taxpayer. The federal regulation in question doesn't really affect this, I don't think. I'm not sure what happened in that conversation. I was not a party to the legislative session that involved the bill in question. I'm just talking as a general condemnation attorney for the cabinet.
So the federal regulation came in just in reference to fair market value, as Representative Decker replied, and we were asked in general why this is required, and the federal statute laid out very cleanly when that type of property right is acquired, what has to happen in the federal process. And so, but I wanted to also say that Representative Decker mentioned something that was discussed with one of our folks at one of our highway districts, and when she and I spoke, I did say that what was told to the constituent at that time was kind of it was trying to be very clear and concise, as we've discussed for the past however long. This is a pretty detailed issue, and so I think that the shorthand by the district was trying to help provide clarity, but in that case left some pretty important things out that didn't leave the property owner with a good understanding of what it was that we were trying to communicate.
Gotcha. I'm going to try my best to put a bow around this as we kind of wind down. You can see Representative Decker's argument from a public policy perspective, sure, and we've had discussions in here about eminent domain, and I've had a lot of problems in my district with eminent domain, to be honest with you. But the state comes in and they buy the property, and it's dueling appraisers, right? And so amazingly, the state appraiser is relatively low all the time in a lot of cases. And so I get my appraiser on the other side that's supposedly spot on, who knows. And then the judge decides. And sometimes they split the difference between the appraisers. And so the state buys the property at a X cost. And, these bypasses, theoretically, they're controlled access where nobody ever again will enter onto the bypass from an entrance ramp. If that's the theory, then there's a lot of bypasses across the state of Kentucky where we failed in that task. But you see the position. Let's take the example of a subdivision. Okay, you have a big subdivision develop. I'm switching gears on you a little bit. There's a big tract of land, 100 acres. State purchased the right-of-way years ago for the road itself, and a new developer is coming along to put houses or subdivision in that area. They are asking for a permit. They're paying for the road to be built. Without the entrance, the property is worth $100. With the entrance and the possibility of subdivision, it's worth $500. The question becomes, from a public policy perspective, is the state of Kentucky entitled to that $400 difference simply that they said yes to the permit and approved the permit? They did nothing they didn't even build the road into the subdivision. The owner of the property is putting their life savings into making this property worth increased value by providing houses to the people of the community. And so I think we have, I think you may have the ability under statute to promulgate the regulation and carry it out. I think the question we're wrestling over is that a good public policy approach? And so I'm assuming the Transportation Cabinet is saying that, in your opinion, that's a good public policy for their state to take advantage of or see that tremendous increase in value that simply signing a permit to allow access to that piece of property. Is that your stance as representatives of the cabinet?
I don't know that I can answer your question exactly that way, but let me just say that any time that the Transportation Cabinet purchases anything, and to include the right to restrict access on a property, that is something that the Transportation Cabinet owns and has paid fair compensation for, and now is the holder of. And at the point that someone asks for something to be done differently, we will go through. And again, because I don't want to contradict what Representative Decker said. Representative Decker said that no deed would change hands or anything. If this is a partially controlled access, then a deed would need to change hands in order to change that with that, so that the chain of title goes through with that. But
so could I
absolutely
push back just a little bit?
Yes, sir.
So this is the way I'm seeing it,
Mm-hmm.
and you can tell me if you think I'm wrong. That's fine. But we have in my opinion, we have two completely different situations. Okay, the first situation is a pure eminent domain situation where the state is following eminent domain, constitutional requirement of eminent domain to acquire the property, and there's this whole process we've set up to do that, and that's the proper thing to do. In this particular situation, this is not reverse eminent domain, right? The landowner is applying to the state for this right and privilege to have the access. In exchange for that access, the landowner is paying, in some cases, paying for the road itself. and they're paying for the application fees and all the sundry things that are required to the state. The state can choose to, in certain instances, I think according to traffic counts and stuff, you guys can decline that application, I think, to do that. And so isn't it kind of apples and oranges, really, that this is, it's not this, I know what the regulation says, that you can do that, but it's really not the same thing, right? It's not eminent domain in reverse.
I'm gonna let John answer that just because I'm not a right of way or real estate professional, and so I just we're not trying to be at odds here. We're doing what we do to try and deliver the public's safe access to different things. So,
Well, let me, Mr. Chairman, thank you. Let me back up. In a general, I agree it's not condemnation. I do think it's a policy decision. It has to be made on a case-by-case basis, starting at the district level, and they have to accommodate safety first. In reference to the legal side of things, though, and the condemnation aspect that occurs, everything that we spend on a project is accounted for. Every dollar spent. If we add an access as part of settlement, we have to calculate the cost because we have to pay for it. It's not free. So I think that's where the heart and basis of keeping the balance sheet probably comes from in the reg. I didn't draft the reg. I'd be happy to amend it if directed to do so. But if we go to a trial in a condemnation case, it's the jury that makes the decision as to value. It's unanimous by the Kentucky Constitution, and they're allowed to present their evidence, and as is the state. So I do see that it's apple and oranges. I would agree with you. But there's also another avenue. The legislature somebody can sponsor a project on that road and change everything. That's also part of this statute and regulation process, is to create a project that alleviates the problem.
I'm going to make one final comment, and then I'm going to open it up to everybody else. Back to the apples and oranges thing. So in one of our examples of the gentleman or entity that wants to build a new factory on the bypass and bring jobs to the county or whatever, let's say they purchased the property. The road went in 20 years ago. The state purchased the property for $5,000 an acre, and they paid the landowner, let's say $60,000. Okay, so the state is out $60,000. You fast forward 20 years. Gentleman intends to build a factory, just wants a road put in. Because it's now an industrial site or a commercial site, the value of that property, it's worth $1 million, and by allowing the road, it all of a sudden becomes worth $500,000. Isn't that really kind of a windfall to the state? You know, we paid $60 for it, and should we really be allowed to recover $500,000?
It could also be a windfall to the private enterprise that gained if you let them have for $5,000 and it's worth $500.
But by the state taking it, their windfall goes away, though, right? Is that?
Well, yeah, I would assume so. Yes, if they condemn the property.
Gotcha. Yeah. So in our policy discussion, the transportation's cabinet's policy is that the state gets the windfall rather than the property owner.
Well,
in that
I
particular
don't know
situation.
that I can answer on behalf of the state on the windfall. I think in this case, the section that was mentioned requires an appraisal be done to consider the fair market value on the date the change is taken.
Yeah.
So, in your example, if it increased in value, the values would have changed over time, yes.
Gotcha.
Yeah, assuming that it went forward and went higher. It could have gone the other way.
And I've spoken too much. I've talked too much today, so I apologize. Anybody else have questions for the transportation cabinet at this time on this particular regulation? Seeing none, do you have something you'd like to add?
Well, I wanted to say thank you for the ability to come over here and discuss this, and happy to continue discussing this with the General Assembly with Representative Decker. And anytime we talk about projects and acquiring property for projects and things, those are, complex items, one property at a time, and we've got a lot of projects that are going on. So I wanted to appreciate the ability to come over and discuss with you all today.
You're welcome. Representative Bridges has a question.
Thank you, Mr. Chair, and appreciate y'all for coming here and explaining this. I see some pros and cons on both sides. Just have some questions, and in instances, are there times you waive this?
I'm not generally a part of the process, so I'm not familiar, but I can get you an answer to that question.
Okay, I'd be interested in knowing that, and what circumstances
Okay.
do you implement it? What circumstances do you waive it? I don't want to, we want to be a state that's business friendly and wants to promote economic development, whether it's growth in subdivision because of our current situation, housing shortage, or whether it's a manufacturer, which is direct impact jobs. But and I am a real estate broker, so I'm familiar with the deed restrictions or plat restrictions, whichever way they decide to put them on the covenants of when they make the purchase. And then but also know that the person paying for this, there's a certain amount of risk, because when you develop a property, just because you build it does not mean they will come. And we can look across this state at failed projects, some significant failed projects. And so I'm trying to bring a balanced perspective here to see, there should be some compensation for the risk put on the developer going in too. And when you want to take everything off the top, it's because that's not guaranteed. I mean, when we do appraisals, it's dependent on what might happen, what may happen, but there's no concrete of what will happen until it happens. So, and the other thing is, I look in here and it all comes back to whether the department makes a decision to do something or not, and that gets into muddy water with me as far as do you have that right to, or should that be in a statute of a black and white way to do this? Because this is not, it's still, this is subjective. And, these kind of decisions, I think, need to have a greater responsibility put upon them, which I see that as elected officials. They should be making those decisions. So I'm questioning both ways. I'm not condemning you. I know this is just put in your lap, and you're caught in the middle because you weren't here 20 years ago when whatever. And I understand there's consequences for decisions you make. If I sell a piece of property and I agree, and the state buys it and they agree, we need to honor our commitments on that end too. So I'm not taking anything away from you guys, but I think in some of this we need to look at where we're headed and what we want for the Commonwealth as a whole. And I think we all can agree that we want growth and prosperity, and sometimes this could limit that. So, because I was just involved in one where the state's wanting to buy a piece of property to put a road in, and the people are pricing it, and the state's saying, no, it's not worth that. Well, the argument is it's not worth it unless you put the road in, and you put the road in, then that property's worth a whole lot more. And they're saying the property owner gets that benefit. And then right here, we're saying they don't get that benefit. So I see some contradictions in the way we go about this. So, I know this is just up for discussion, but it'll give us a lot to chew on for in the future to see what direction we need to move. But I do appreciate you gentlemen. I appreciate Representative Decker, and it's like a rubber band being pulled. And when it comes down to that, I think it's the legislator's responsibility to make that decision. So thank you very much, gentlemen.
Would you guys like to respond to that at all now, or?
And just say that the Transportation Cabinet, we're at the core of our mission is, enhance quality of life for Kentuckians and providing economic opportunities. And so those are, we concur. Those are things that we're working really hard through our projects and to provide those types of things for Kentuckians as well. So thank you for your comments.
If you guys want to stay right there, I'm going to bring Representative Decker up one last time. She has a quick comment, and then we'll wrap this whole thing up.
Thank you. And thank you all. The whole time I've worked on this, the Department of Transportation has been very kind. And of course, as a lawyer, I'm used to having legal disputes and not feeling animosity. So I really appreciate their attitude. There are just a couple of things I think need to be clarified. There was a comment that you're not sure if this is a limited access or an access by permit road. That is the only type of road that regulation, section 4.6, applies to.
A partially controlled access, yes, ma'am.
No, it says the name of the regulation is do you have it there?
I have it right here, ma'am.
Is the procedure, section 6,
It's on over.
section 4.6. The name of it, the name of section 4 is processing requests for changes in access by permit application. So that's the kind of road we have, and that makes a big difference because when we're talking about the price that was paid, things that were guaranteed or sold, on that type of highway, there is an anticipation that permits will be requested. Again, it's not the highway, it's not the type of road that never anticipates and so price is paid knowing that you're forever taking that away from this is an access by permit road. It is anticipated, so I'd say the cost paid would have had that in mind. The other point I wanted to make is that Representative Bridges asked, are there times that this is all waived? The regulation that was cited to me, I have it in statute, the federal regulation says you pay fair market value except in 6 situations. And one of those situations is when it's for the common good of the community. So yes, that very reason that we're asking for it is noted as an exception, that even if that federal rule applies to all state roads, this is one in which that exemption would matter. Those are my comments. Thank you.
Thank you so much. First of all, I want to say thanks to the cabinet, and thanks for coming over here on such short notice. I apologize for the short notice, but things percolate around here in different ways. And we purposely set up, I had some conversations with Representative Decker, and that's why we're here today. And we purposely set this up as information only. So I specifically spoke to each member, no action taken today, on and on. So thanks for the information today. We really, really appreciate it. This is a serious policy consideration. And if we want to change this as a legislature, we can. But we would have to notwithstand a few statutes and change that. But this is a good first step. Main thing we want to accomplish today is get the information out to all of our members. Get the transportation cabinet side of the story, right? Get your side of the story, how it actually operates. So I think we've accomplished that today. That's it. Any other questions?
Thank you.
Seeing none, please call the next regulation. Thank you.
Agricultural Experiment Station, 12 KAR 1-134, 1-144, 1-149, 1-164. All regulations have staff suggested amendments.
12.1.134 through 164 establish new administrative regulations for seed, including labeling requirements, label fees, registration of dealers, non-certified custom seed conditioners, certified seed growers, and certified seed conditioners, stop sale orders, and germination standards for vegetable seed. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Good afternoon. Station name for the record.
Good afternoon. Stephen McMurray, Executive Director.
There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion and a second. Without objection, is so ordered. I can guarantee you will not have as many questions as the last presenters.
That'd be great.
But I've been wrong before. We'll see. Any questions for this gentleman on this set of regulations? Seeing none, please call the next regulation. Thank you.
Thank you.
Office of the Governor, Department of Veterans Affairs, 17 KAR 3042, which has staff suggested amendments.
17 KR 3042 establishes a new administrative regulation containing the eligibility requirements for admission to state veterans nursing homes. The amended after comments version removes 2 of the 3 criteria for which a person shall be deemed ineligible for admission to a state veterans nursing home and maintains that a person shall not be eligible for admission if the person has needs that cannot be met by the Veterans Center. The staff suggested amendment amends the title, relates to statutory authority and necessity, function, and conformity paragraphs, and Section 1 to correct statutory references and comply with the drafting requirements of KRS Chapter 13A.
Will you state your name for the record?
Mark Bowman, Executive Director.
Thank you. There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection, it is so ordered. Any questions from members on this regulation from the Department of Veterans Affairs? Seeing none, I do have one question. We've been a lot of tension on the backlog at these veterans facilities, and people being allowed to get in there. I'm assuming this regulation aims to open that channel up. And
Yeah, it really just takes some what I would call more restrictive language out. But it's always going to be an assessment based on that person's needs and the facility's ability to meet them.
and this is the goal of the regs. Part of the goal
yeah.
is to do that. Senator Yates has a question.
Thank you. Just noticing that, so there was under subsection 2 and the eligibility, it laid out where a person shall not be eligible for admission. We've taken under the subsection A out where it's diagnosed with qualified healthcare professional as acute mentally ill, but also as acute alcoholic or addicted to drugs. Would that allow through the veterans? Would they be able to allow to have rehabilitation centers through there, or is that just to keep that from just being a no longer admitted?
It's really taking away the strict restriction of it.
Okay.
So, yeah, so it'd still be an assessment based on that person's need at the time of admission.
So it could be now it's no longer a stoppage point.
And it's absolutely not in, yes.
Okay, thank you.
Any other questions? Seeing none, please call the next regulation. Thank you.
Kentucky Public Pensions Authority, 105 KAR 1200 and 1202. 105 KAR 1200 has staff suggested amendments.
105-1200 amends provisions for public employees to apply and receive retirement benefits, to establish definitions, update service and disability requirements, clarify what constitutes an invalid retirement notification and the related procedures, update tax withholding provisions, revise matters related to death benefits, update payment procedures, clarify provisions pertaining to leave balances and hospital and medical insurance, and update incorporated material. The staff suggested amendment amends various sections to comply with KRS Chapter 13A and amends Section 3 to align with current agency procedures. 105-1202 establishes provisions for the use of notification of retirement Form 6000.
Would you please identify yourself for the record?
Nathan Goodrich, Staff Attorney Supervisor.
Carol Catalfo, Policy Specialist.
Thank you so much. There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second without objection, so ordered. Any questions from members on this set of regulations dealing with public pensions? Seeing none, please call the next regulation. Thank you.
Boards and Commissions, Board of Pharmacy, 201 KAR 2416 has a staff suggested amendment.
201-2416, as initially filed, establishes the process for pharmacies to report data to the Department of Insurance in accordance with KRS 315.038. The amended after comments version clarifies data security requirements and data confidentiality provisions required by KRS 315.038. Establishes square footage allowances if a pharmacy shares a building with retail space. Establishes that data may be submitted in aggregate for pharmacies with multiple locations, and establishes enforcement discretion for a pharmacy that does not bill third parties in the event that the pharmacy fails to submit required data. The staff suggested amendment amends various sections to comply with KRS Chapter 13A and amends Section 1 to include that a statutorily established data submission shall be every other year after 2026.
Would you please identify yourself for the record?
Jessica Brown, General Counsel.
Chris Harlow, Executive Director.
There's a staff amendment. Is there a motion for approval of the staff amendment? We have, oh, okay. Brief pause. I wasn't used to the brief pause, sorry. We have a motion and a second without objection. So ordered. Any questions for members on this regulation from the Board of Pharmacy? Seeing none, please call the next regulation. Thank you.
Board of Social Work, 201 KAR 23012 and 23025. 201 KAR 23025 has staff suggested amendments.
201 KR 2312 establishes and incorporates by reference the rules adopted by the Social Work Licensure Compact as of February 5th, 2025. 201 KR 2325 establishes requirements and procedures for social worker licensing to replace a repealed regulation, including definitions, application requirements, a $25 non-refundable application fee, additional requirements for LCSW licensure, and the licensure application and supervised experience documentation forms. The staff amendment amends various sections to comply with KRS Chapter 13A and amends Section 3 for consistency with the material incorporated by reference that includes documentation of 150 hours of clinical supervision and requirements for LCSW applicants in another jurisdiction if licensed for less than 2 years and if licensed for 2 years or more. Additionally, the agency filed an updated regulatory impact analysis and tiering statement to update its answer to question 3.
Would you identify yourself for the record?
Hank Cecil, Chair of the Kentucky Board of Social Work and Chair of the Social Work Licensure Compact.
Mark Bringelman, Contract Counsel to the Board of Social Work.
There is a staff amendment. Is there a motion for approval of the staff amendment? Motion and a second without objection, so ordered. Any questions from members to the Board of Social Work? Seeing none, have a nice day.
Thank you.
Thank you.
That concludes our agenda for today. We have the next meeting scheduled for August 12th. Does anyone have a known conflict with August 12th?
That's Tuesday at 1 p.m.
Tuesday at 1 p.m. Seeing none, we'll be in touch. Have a nice day.
So good luck on those,